Welcome to this week's New Knowledge here at the Virginia Highlands Small Business Incubator. We are excited to have with us today Ramesh Murthy. Ramesh is a native of Tazewell County, Virginia. He's a graduate of King University and the University of Richmond School of Law. Go Spiders! For over 30 years, he was a member of the firm at Penn Stewart in Abingdon, Virginia. And he recently transitioned to Hancock Daniel, where he's a partner in the firm, whose primary practice area is healthcare and employment law. He's certainly very well known in the community and active as chair of the board of directors at Sullins Academy and a member of the board of trustees of the Barter Theater Foundation as well. I've known Ramesh for over 30 years when we were in law school together. He's a great guy. He's a go-to fellow when you need him for employment matters. So we're very excited to have him with us today here at New Knowledge, where he's going to speak about employment law. So please welcome Ramesh Murthy.
All right. Thank you so much, Mark. Those are truly the kindest things you've ever said about me. So first of all, I want to thank everyone for attending this. This post-COVID, doing these presentations via Zoom is not as exciting as doing them in person, but I certainly understand, and this is a very convenient way of doing things. So I feel like I'm basically talking to myself, but feel free to chime in with any questions or comments. Generally, even if I'm speaking to an audience, I prefer them to be interactive or interactive presentations. But as the release for this presentation indicated, when we think of employment law, we think of a broad umbrella of many complex and varied state and federal rules, regulations, and laws. This presentation is certainly not intended to be legal advice, but simply an opportunity for me to assist you in gaining a greater understanding of some of the basic framework of employment laws to help you more efficiently and appropriately run your businesses. I will say, once you learn more about human resources or employment law, it is always amazing to me how human resource professionals can keep track of everything, because there are always a lot of moving parts, and factually every situation is different. So it really becomes difficult. This isn't a sales pitch, but I would suggest that you certainly gather a relationship with an employment lawyer of your choosing, whoever it is, to help guide you through some of these issues, because they are complex and they are varied. As Mark indicated, I have been practicing in September, it'll be 35 years. The only area of law I've been practicing in is employment law, which includes, in this area particularly, a lot of workers' compensation. I did transition to Hancock Daniel in April of last year. Just so you know, we have approximately 65 lawyers and we have a national footprint. I've been in Southwest Virginia, East Tennessee area my entire career. I handle matters all over Virginia and Tennessee, but my office is in Abingdon. I live in Bristol. I'm local. I grew up in Richlands. But I've been very blessed to have a varied and good-sized client base that I appreciate. And as part of my work as an employment lawyer includes guiding and counseling employers as well as litigation. Although I'm a litigator and I do enjoy being in court and litigating, what I truly appreciate in employment law is helping guide and counsel clients to help them navigate some of the complexities of employment law. I've drafted handbooks for employers, assisted employers in creating policies, assisted in investigations. I've represented them during EEOC investigations, OSHA or VOSH in Virginia. I've represented clients before the Virginia Workers' Compensation Commission, the Virginia Employment Commission, and even before the National Labor Relations Board. So now that we've moved past the shameless pitch, let's talk about the basic tenets of employment law. It should come as no surprise that the basic tenets of employment law are to ensure a fair playing field for employers and employees. I will say, if anyone has trouble hearing me or anything, just you can put in the chat or speak up, and I'm happy to do what it takes, because I want to make sure that you can hear me. But as I tell folks all the time, human resource issues many times just follow common sense rules. If what you're doing seems wrong, it probably is. Um, I always use the adage, look in line behind you at Food City or wherever, whatever store you're shopping at. Those are the folks that are going to be sitting on juries that will make determinations as to whether or not your actions were appropriate or not. So keep that in mind. It's as basic as that. Because I've always represented employers, I'm not one of these who falls into the trap of thinking employers are always trying to do the wrong thing. In fact, I know employers are trying to do the right thing because suffering the consequences of doing the wrong thing never makes any sense. However, what we want to talk about today is what is right and what is wrong from a legal standpoint. Broadly, we know employers have to pay a fair wage. We know employers have to provide employees with suitable working conditions and allow them to work in circumstances in which they are not subject to discrimination or harassment, particularly because of a trait over which they have no control. And that's one thing I'm going to talk about a little bit. For example, as you can tell from looking at me, I'm of Indian descent, even though my accent doesn't match my look. But I have no control over that, right? I have no control that I'm of Indian descent. If I have a disability, generally I have no control over having that disability. These are things to keep in mind because many times in the law, what we're looking at is who is in a protected class. And generally those that are in a protected class, to prevent them from being subject to discrimination or harassment, they have no control over those traits. Being a female, being a male, whatever it is, I have no control over that. So again, generally the laws are designed to prevent discrimination of individuals on account of their race, religion, disability, age. Again, I can't change my age. So when you do a 30,000-foot overview, what you see is that's the consistent theme. Protecting people from things they can't control for the most part, and there are exceptions to everything. However, there are also broader employment laws. For example, what is a fair wage? What are your rights to discuss your wages with coworkers? Can an employer prevent me from going to work for a competitor? You have to give your employees breaks. If so, how many and for how long? The answer is no, but we'll get to that. What happens if one of your employees is hurt on the job and is disabled? What happens if one of your employees is hurt off the job and is disabled? All of these are the types of issues that human resource professionals and you as employers have to deal with on a day-to-day basis. So having a basic understanding of the framework of employment laws will assist you in accomplishing your tasks more efficiently. I certainly don't expect you to know all of the employment laws or all of the intricacies of employment laws as a result of this presentation. But I would like for you to do is gain a better understanding of the reasons behind some of the laws and a basic understanding of the laws themselves. This is not designed to cover all the employment laws, or otherwise we'd be here for weeks. But just to highlight some of the laws. So to start with, we have federal laws. As you know, Congress enacts laws that apply on a federal level. If they enact a federal employment law, it applies to employers and employees in Virginia, Tennessee, Kansas, wherever, right? Hawaii, anywhere in the United States. And there are state laws that we'll talk about shortly that, of course, the Virginia General Assembly passes that apply to you as a Virginia employer. So always keep in mind, federal law, state law, you may be subject to both. You may not be subject to all of it. You know, it depends on the thresholds, and we'll talk about the thresholds. The first federal act, we'll talk about federal laws quickly because, I know there's a focus on small businesses and employment laws that affect them, but the definition of a small business is varied. And I will tell you what the laws are and what the thresholds are, and you can determine whether or not you as an employer fit within these laws or whether these laws are applicable to you. The first one is the Title VII of the Civil Rights Act of 1964. This applies to employers with 15 or more employees, including part-time and temporary workers. Even if you have less than 15 employees at the time a lawsuit is filed, you may still meet the criteria for coverage under the Act if you had 15 or more employees for the 20 weeks in the preceding calendar year. Title VII, and I'm sure all of you know Title VII, but Title VII makes it unlawful for an employer to discriminate against any individual with respect to his or her compensation, terms, conditions, or privileges of employment because of an individual's race, color, religion, sex, or national origin. To determine if there is coverage, the employer includes 15 or more employees for each working day in the 20 or more calendar weeks in the current or preceding calendar year. Again, this includes part-time and temporary workers. I won't go into all of the details of the mechanisms, but generally what we see is the law is designed to protect people in these protected classes, right? So non-white, so race, color, religion, etc. They're in those classes, and therefore they have certain protections under Title VII because they're in those classes. But what we see is when someone believes they have been discriminated against or harassed under Title VII, they will file a charge of discrimination with the Equal Employment Opportunity Commission. And there are other intricacies on the state level that we can discuss and will discuss shortly. So the Equal Employment, or the EEOC, will take in the charge and then will send that to the employer for a response. I will say I've handled a lot of these, and I have seen a variety of approaches. Again, I'm not shamelessly selling legal services, but I would strongly recommend that you find an employment lawyer of your choosing to help you respond to those charges. I've seen folks respond to the charges that have resulted in more problems than what were there to begin with because of how the response was filed. So get some legal guidance on that. So you file a response to the charge, and then the EEOC has the ability to investigate the charge, which includes interviewing employees on site. First of all, they look at the charge, they look at the documentation, they look at the response. And if need be, they may come do an investigation on site. I've been part of that on several occasions. And then upon conclusion, they issue a letter, which is called a right to sue letter. So once the letter will say there has been a violation, there hasn't been a violation, or they haven't had time to investigate it, but they will issue a right to sue letter. And once that letter is received, even if the EEOC finds that they could not find a violation of law, that right to sue letter is a ticket for the employee to go to federal court and file suit. So EEOC doesn't have to find a violation for the employee to have a right to file suit, but they do have to go through the EEOC process before they can file suit. Suit has to be filed within 90 days of receipt of the right to sue letter. So many times if we get a charge or a finding from the EEOC that says no violation, we calendar it for 90 days to make sure no suit is filed. And many times no suit is filed, but there are times when suit is filed and we have to deal with the suit. From time to time, the EEOC finds the employer's conduct or practice to be so severe or offensive that they will actually institute suit against the employer. As you can imagine, that is certainly not a situation you would want to find yourself in. So again, Title VII covers discrimination on account of race, I'm sorry, not age, but race, color, religion, sex, and national origin. The next federal act is the Age Discrimination in Employment Act, or the ADEA, as we know it. This applies to employers with 20 or more employees. I would note that the Supreme Court has concluded that this ADEA applies to all state and political subdivisions, regardless of their size. And as you can imagine from the title of the act, it prohibits age discrimination. You should note that to be protected under the ADEA, as it is known, you must work or apply for a job with a company that meets the size requirements. So excuse me, so 20 employees or more, and you must be 40 years old or older. So that's the cutoff. You become part of the protected class on account of age if you're 40 years old or older. If you're 38, you're not protected. If you're 42, you are protected. So again, I'm not going to go into intricacies of it, but that is an act that applies to you. And again, broadly, if you step back and look at all of this, whether you meet the threshold or not, you don't want to discriminate against anybody for any reason, honestly. I mean, on account of age or these types of personal traits. That's, again, common sense. Just stay away from it. Another federal law that I want to touch on briefly is the Americans with Disabilities Act. The threshold for coverage under the ADA, as it's known, is 15 or more employees. So we have 15 for Title VII, 20 for the ADEA, and 15 for the Americans with Disabilities Act. There are several titles within the Act, but the one that pertains to our discussion today for private employers, it protects qualified individuals with disabilities in several areas, including job application procedures, hiring, firing, advancement, compensation, and job training. It also renders it unlawful to retaliate against someone for opposing employment practices that discriminate based on disability. This is a very generalized version, as you can see, but what typically happens in these scenarios is that an employee makes the employer aware of certain needs for accommodation on account of disability. So an employee comes to you as an employer and says, I have this disability that prevents me from doing portions of my job. I will tell you, and sometimes it's hard for people to believe, but we are all disabled under the Act. So in my personal view, that is disability. Being able to prove disability is incredibly easy. However, for purposes of discussion, what amounts to a disability is a physical or mental impairment that substantially limits one or more major life activities. So what's a major life activity? Well, it includes walking, seeing, hearing, learning, working, caring for oneself, eating, sleeping, communicating, and the impairment makes it significantly more difficult or impossible to perform a major life activity compared to people who don't have the impairment. And the impairment has lasted for 6 months or more, or it is expected to recur or continue indefinitely. So that's kind of the test. Now, it should be noted that temporary impairments, such as a broken foot or something, are not covered under the Americans with Disabilities Act. So it has to be more of a long-term kind of condition. So what happens is an employee comes to you with a request for accommodation based upon an impairment or disability that meets these criteria. You have a sufficient number of employees and they have an impairment that we outlined earlier. They come to you with that. Generally, the thrust of this act is in the next step, and that is the employer is then required to engage in the interactive process with the employee to try to get a better understanding of the impairment or disability and discuss the essential functions of the job and how accommodations can be made to allow the employee to perform the essential functions of the job with or without reasonable accommodation. So basically, you sit down with the employee and go over what their documentation is or what their concerns are or what their inabilities or impairments are. Look at the essential functions of the job and try to make a determination as to what they can and can't do, and then how you can accommodate the job to allow them to continue in that job with that accommodation. That is not a throwaway issue. I will say employers do, and I would strongly recommend that you make a good faith attempt to go through the process. It's not a pro forma process. I would go through the process and document how you went through the process and how you arrived at the decision that you arrived at. If there's an ability to accommodate the essential functions of the job to allow the employee to continue in that job, you must do so as an employer unless it will create an undue hardship upon you as the employer. An undue hardship is generally known as an accommodation that would be too costly, disruptive, or fundamentally alter business operations. For example, it could pose a significant financial cost. And many times what will be looked at is, if this ever goes to court or further investigated, is they would look at the financial stature of the employer, the cost of the accommodation, to make a determination as to whether in fact it is a significant financial cost that constitutes an undue hardship. The hardship may also be because the accommodation would create a significant safety risk, and then also infringement, meaning the accommodation might infringe upon other employees' rights or benefits. Again, simply saying that it would create an undue hardship is not enough. In my estimation, a reasonable effort should be made to assess the situation and be able to provide documentation supporting the claim of undue hardship. Now, keep in mind throughout all of this, a threshold element is that the employee must be qualified, a qualified individual, which is someone who meets the job requirements and can perform the essential functions of the job without reasonable accommodation. And I say that because, I know that you could say, well, if they're already in the job, aren't they qualified? And the answer is generally yes, but the Americans with Disabilities Act also applies to denying someone employment. Someone applies for a job, makes you aware of this impairment, and you don't accommodate them, and they're a qualified individual, they may well have a claim under the Americans with Disabilities Act. So it's not just existing employees, it's also employees that are seeking employment with your organization. So we've talked about what a qualified individual is. Someone who meets the job requirements and can perform the essential functions. I'm sorry, qualified employment means you have to be qualified to do the job, right? So for example, they must be able to meet the job's educational requirements, experience, skills, another example. So this is a farcical example, but for example, you're advertising to hire a neurosurgeon. And this is a stupid example, but I'll give it to you. And someone applies and they claim a violation of the Americans with Disabilities Act because you didn't hire them because of their impairments. Well, if they don't have a medical degree, they're not a qualified individual. It's kind of a drastic example, but it highlights exactly what is required in order to meet the threshold requirements under the Americans with Disabilities Act. Again, if there is a complaint that you have violated the Americans with Disabilities Act, the employee would file a charge of discrimination, and we would go through the process that we've previously discussed. Another federal law, and I promise I'm going to get to Virginia laws, another federal law that likely won't apply to your organization because of the threshold employee requirement, but I will mention it to you. And everyone knows it. It's the Family and Medical Leave Act. To be considered covered under the Family and Medical Leave Act, the employer must have at least 50 employees to be covered. And you're required to provide leave to employees under the Act. So for broader context, 50 employee threshold is based upon the total number of employees the company employs across all locations within a 75-mile radius of the employee's work site. And again, similar to what we discussed earlier, the employer must have employed at least 50 employees for 20 or more work weeks in the current or preceding calendar year. For the employee to gain entitlement to coverage under the Family and Medical Leave Act, they must have clocked in 1,250 hours in their last eligibility year. So it's not for short-term employees. They have to have put in 1,250 hours of work. The FMLA entitles eligible employees of covered employers to take unpaid job protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. Eligible employees are entitled to take 12 weeks for the birth of a child, and I won't go through all of this, but the placement of the child for with taking on a child, adopting a child, that's what I'm trying to say, adopting a child or a foster child, care for a new child, new baby, serious health condition, to care for an employee's spouse, child, or parent who has a serious health condition, the employee's own serious health condition that makes the employee unable to perform the essential functions of his or her job. And there's also qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty, or they may also take 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness, if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin, military caregiver. So if you meet the threshold, that's kind of the criteria you must meet. But I think the thing to keep in mind is under the FMLA, if the employee takes leave and then returns to work, they must be returned to their same or comparable position. It doesn't have to be the same position, but it has to be a comparable position. And their benefits have to be maintained during this time period. And I will tell you, in human resources, we get all kinds of questions, and it's always amazing to me how creative some employees are. For example, years ago, I had someone called me saying that they were requesting leave under the Family Medical Leave Act, and this was a covered employer, because the employee's cat was sick. And of course I said, well, that's not covered, so they don't have coverage to take care of their cat. Well, then 2 hours later, the employer called me back and said, now they've brought in documentation that they're depressed because their cat is sick. So it's pretty creative. And I said, well, they're getting closer to obtaining leave under the Family Medical Leave Act. But those are the types of factual issues you have to deal with. And we see it all constantly. I'm part of an employment law team here. We have 5 lawyers that handle employment law matters all over, and we do see it all. So the next federal law is the Fair Labor Standards Act, which is, or FLSA as we call it, which establishes a minimum wage, overtime pay, record keeping, child labor standards affecting full and part-time employees. Now, who is covered? What employers are covered? Generally, all employees of certain enterprises having workers engaged in interstate commerce, producing goods for interstate commerce, or handling, selling, or otherwise working on goods or materials that have been moved in or produced for such commerce by any person are covered by the Fair Labor Standards Act. Generally, it applies to employers who have an annual gross volume of sales made or business done is $500,000 a year. There are some exceptions that I'm not going to bore you with, but that's kind of the qualifying threshold. There are many rules and policies with the Fair Labor Standards Act that, again, I'm not going to bore you with. But however, there are certain employees who are exempt from overtime pay, and there are certain rules and regulations in terms of managerial status, et cetera, that exempt them. But we're primarily, now, making sure you've classified them properly is critically important, because misclassifying can have huge ramifications. But if in fact they're non-exempt employees, then they are covered. They're entitled to overtime pay. They're entitled to some of these benefits that the Act is designed to offer. It essentially ensures that non-exempt employees who are covered receive the appropriate overtime compensation, and that there are penalties assessed against employers who fail to pay the appropriate overtime compensation or compensation in general. Like every federal act, retaliation against employees who complain about non-compliance with the act is strictly prohibited and is actionable. Contained within the Fair Labor Standards Act is the Equal Pay Act, which prohibits sex-based wage discrimination between men and women in the same establishment who perform jobs that require substantially the same or equal skill, effort, and responsibility, and are performed under similar working conditions. Again, there are some exceptions, but I won't go into that. So you have the Fair Labor Standards Act, you have the Equal Pay Act. Now, I mentioned the retaliation provision, and I'll just talk about this in a second. All of these acts have anti-retaliation provisions. And why is that important? Well, let's take the Fair Labor Standards Act, for example, or any of the acts, actually. Someone can allege, for example, and I'll not use the Fair Labor Standards Act, but someone can allege discrimination, that they've been discriminated against. And you know that to be untrue. And you, whatever it is, you are very secure in knowing that that's not true. And then because you're incensed by the fact that they've even made that claim, you take action against them, and punish them somehow or reprimand them somehow for even making the claim. They file a charge of discrimination, and the EEOC comes back and says no violation, and then they file suit. When they file suit, they're going to allege discrimination, right? The underlying claim, the underlying charge of discrimination, or the underlying complaint of discrimination. But they're also going to allege retaliation. And many times what happens is it's a lot easier to prove the retaliation claim than it is to prove the discrimination claim. And you don't have to prove the discrimination claim in order to prevail on the retaliation claim. So they could actually prevail and have a much easier path to prevail because of the retaliatory conduct, as compared to had you not retaliated and they had simply litigated the substantive discrimination claim, which you knew you had a strong position on. So you win on discrimination, but you lose on retaliation. So in the end, what's happened? You've lost at a significant expense. I will tell you, litigating cases in federal court is not for the faint of heart. It is expensive. And many of these statutes have attorney's fees provisions, which if you lose, force you to pay the other side's attorney's fees. So you're paying your attorney. If you lose, you're paying the claim, and you're paying their attorney. And it can get very costly. For example, under the Fair Labor Standards Act, and I've seen this many times, where there has been a violation, but the amount of overtime that the employee was shorted, and it wasn't done intentionally, but the amount of overtime that the employee was shorted, let's say, is $3,000. Yet to go through that federal court process, their attorney has documented $75,000 in attorney's fees. So there has been a violation. You know, there's the damages equate to $3,000. So you pay the $3,000, but arguably you're going to also have to pay the $75,000 because the violation was found, or they found that you did not comply with the Fair Labor Standards. And that is a big concern. And that's why it's very important to dot your I's and cross your T's. So again, retaliation, keep that in mind. It is, someone once told me, it's like a black dress. Retaliation goes with everything. Always beware of retaliation. Always keep in mind, if someone is exercising their rights, even if you don't agree with them, that is not the time to punish them or reprimand them for doing so. Now, another act that I will talk about briefly is the National Labor Relations Act, or NLRA. It's a federal act. We generally think of this when we think of unions or collective bargaining. But I will tell you, the NLRA covers essentially any private sector employee with employees engaged in interstate commerce. And what oversees it is the National Labor Relations Board that has some jurisdictional standards. Again, they look at the gross volume of sales of $500,000. But the minimum number of employees required for NLRB, or National labor relations board jurisdiction is 2. This again is assuming the employer meets the interstate commerce test. However, I will tell you, because people view it as just dealing with unions, they really pay no attention to it, the NLRA, but they should be paying attention to it, because I have seen over and over violations of the NLRA by private sector employers. It's unknowing, but it's a violation. The NLRA seeks to protect employees from exercising their rights to discuss the workplace, but also to potentially engage in collective bargaining. Therefore, any policies or procedures that prohibit or dissuade employees, for lack of a better phrase, from speaking ill of their employer could very well be a violation of the National Labor Relations Act. In addition, you should not prohibit or limit your employees from discussing their wages with one another. I know many employers that do that, and that is prohibited, because if they're unable because of your rule or policy to discuss their wages or their complaint about their wages with you as a co-employee, that hinders their ability to gain knowledge about the employment circumstance, and thus hinders their ability to potentially engage in collective bargaining. So these are the types of issues that you have to consider. You also cannot prohibit your employees from discussing their workplace conditions with one another, even if it comes in the form of complaining to one another. That is a violation of the NLRA. So keep that in mind. Just because we think it affects unions, it also affects you as employers. Take a look at your handbooks. See if you have policies or procedures that may violate the NLRA, or ask a professional to do that for you. I think that's very important. And while we're on that topic, I think it's very important annually, or at least every 2 years, to have someone review your employee handbook, whether it's a lawyer or some HR consulting company, whoever it is, someone that you trust to review your handbook to make sure you're in compliance, because the legal landscape changes a lot, and it changes daily. So you always have to be on top of things. Now let's talk about Virginia law. I've been yapping here for a while, and we'll get through all of this, but now we've discussed the federal acts and the size threshold for employers, but also there are state laws that apply to you as Virginia employers. Of primary importance, and they're all important, but we're going to talk about the Virginia Human Rights Act, and as we will discuss, the Virginia Values Act. You will notice a consistent theme throughout all of this, and that is in 2020, there were huge changes to the employment law landscape in Virginia, or under Virginia law. We'll discuss that. Prior to 2020, the Virginia Human Rights Act provided that no employer employing more than 5 but less than 15 persons shall discharge any such employee on the basis of race, color, religion, national origin, sex, pregnancy, childbirth, or related medical conditions, including lactation. It also provided that no employer who employs more than 5 but less than 20 shall discharge any such employee on the basis of age. And again, the threshold was the age of 40. So the latter part, the discharge provision, mimics the Age Discrimination in Employment Act. If there's a violation, the court can award attorney's fees. This is pre-2020. The court could award attorney's fees for amount recovered not to exceed 25% of the back pay award. The court was not able to award other damages, including compensatory or punitive damages, nor could it order the reinstatement of the employee. However, in 2020, as I mentioned, there was mass expansion of Virginia law. The Virginia Human Rights Act was expanded with the passage of the Virginia Values Act. Now, it did change the thresholds a little bit. Under this, employers employing 15 or more employees for each working day in each of the 20 or more calendar weeks in the current or preceding year were covered. Um, the terms because of race or on the basis of race, in terms of race discrimination, were defined to include because or because of or on the basis of traits historically associated with race, including hair texture, hair type, protected hairstyles such as braids, locks, twists. It further defines sexual orientation to mean a person's actual or perceived heterosexuality, bisexuality, or homosexuality. It defined gender identity as gender-related identity, appearance, or other gender-related characteristics of an individual with or without regard to the individual's designated sex at birth. It also expanded the law to include veteran status to protect those with veteran status. More importantly, the act prohibited employers from discharging an employee on the basis of a protected class, but it also prohibited employers from engaging in the following acts against against employees or applicants for failing or refusing to hire or otherwise discriminating against an employee or applicant, limiting, segregating, or classifying applicants or employees that would deprive them of opportunities or otherwise adversely affect them, using a protected class as a motivating factor in an employment practice, even if other factors motivate the practice, and punishing advertisements that are discriminatory or that suggest a preference or limitation based upon a protected class. So you can see how the act was expanded to, lack of a better word, be all-encompassing. So we talked about the threshold of 15 or more, but at smaller employers, those with 6 to 14 employees continue to be subject only to the discharge claim as under prior law. So this expansion of additional types of claims only applies to employers with 15 or more employees. Now, why does this matter? Because the act also changed damages to which an employee may be entitled to under this 2020 amendment to the Virginia Human Rights Act. Under the amendments, a private right of action was created against all covered employers for any form of discrimination and not just discharge. It expanded damages that could be awarded to unlimited compensatory damages, punitive damages, attorney's fees and costs, as well as temporary and permanent injunctive relief. So again, if you lose, you pay your attorney and you pay their attorney. In order to avail themselves of these types of, or to file these types of claims, the employee has to file a charge of discrimination with the Virginia Office of Civil Rights in accordance with the EEOC's timeline, which, as you know, or may not know, is 300 days from the date of the last discriminatory act. So if it's a continuing discrimination, then that statute keeps moving. And the employee must receive a right to sue letter before filing a civil action. Also effective July 1st of 2020, employers employing 5 or more employees are required to provide reasonable accommodation to applicants and employees who are experiencing pregnancy, childbirth, or related medical conditions, unless doing so would pose an undue hardship. So it kind of melded in a portion of the Americans with Disabilities Act, but as it's limited to pregnancy, childbirth, or related medical conditions. Such actions would have to be commenced within 2 years of the adverse action, or 90 days from date of receipt of a right to sue letter. Employers are also required to post information about the prohibition on discrimination and the right to reasonable accommodation in a conspicuous location and include that information in their employee handbook. Again, this is a reason I recommend having someone review your employee handbook annually, or every 2 years, the longest. In addition, this information about accommodation and the like must be provided to new employees within 10 days of an employee, not new employees, but employees within 10 days of an employee providing notification of her pregnancy. So that's a lot to consider. The next act, I'm gonna do it on time here, is the Virginia Wage Payment Act. Well, let's start with the Virginia Minimum Wage Act. This act was essentially a non-factor before some of these drastic amendments, because there were exceptions for those who were covered by the Fair Labor Standards Act, and most people were covered by the Fair Labor Standards Act. So all of this changed this year, and the exceptions were drastically reduced. And under the amendments, they also implemented a series of minimum wage requirements. And you will note that this was in 2020, they instituted these incremental minimum wage changes. And I will tell you right now, the minimum wage in Virginia is $12.41 an hour. I will tell you there's a bill that was passed in this year's General Assembly that is, we don't know what the government will do with it, but that is seeking to raise the minimum wage to $15 an hour by 2027. The minimum wage was scheduled to go up to $13.50, I think, this year, but last year the governor thought that that was too much of a burden on small businesses. So that's why it only went up to $12.41. Skipping down to the Virginia Wage Payment Act. This is also a 2020 amendment by the General Assembly that allows employees to sue individually and collectively employers for failing to pay wages. This is under the Wage Payment Act. There's a 3-year statute of limitations. Courts are permitted to award damages in the amount owed, liquidated damages, prejudgment interest, and attorney's fees and costs. So again, you're going to have to pay the other side's attorney's fees. If it is found that the employer knowingly failed to pay wages properly, the court is required to triple the amount of wages due and reasonable attorney's fees and costs. In 2020, the act was also amended to prohibit action against employees who have filed a complaint or instituted proceedings for non-payment of wages. Again, this is a retaliation provision. Now, the employee cannot file suit for this, but what they do is they file a claim with the commissioner at the Department of Labor and Industry, and with the employee's consent, the commissioner files suit against the employer. And damages can be awarded for retaliation, including reinstatement to that position, lost wages, and liquidated damages equal to lost wages. To go through these last parts, but another hot topic is non-competes. In 2020, the General Assembly enacted legislation that prohibited employers from entering into, enforcing, or threatening to enforce any covenant not to compete against a low-wage earner. So many times employers have rules in place that if you come to work for me and that you separate from my work, you can't go back and work for a competitor within a 30-mile radius or whatever it is. If the person is a low wage earner, that is no longer legal. The law expressly prohibits covenants to restrict them. Well, in addition to that, prohibiting that, the law also expressly prohibits covenants to restrict an employee from providing a service to a customer. And this is an employee that's left your employment and gone to someone else. You can't prohibit them from providing service to a customer or client of yours if the employee does not initiate contact with that customer or client. So if the landscape of the claim is someone leaves your work, separates from you, goes to work for a competitor or sets up their own shop and starts working with one of your clients or customers, you can't take, assuming they're a low wage earner, you can't take action against them if the employee did not initiate contact with that customer. If the customer liked them so much they called them, you're out of luck. Now, the law does permit non-disclosure agreements intended to prohibit taking, misappropriating, threatening to misappropriate, or sharing of confidential information or trade secrets. Now, I did skip over this, but what is a low wage earner in Virginia? Someone making $73,320 or less. So it's a high threshold. If the employer violates this provision, pertaining to non-competes. And I will tell you, I have seen this as it pertains to low-wage earners. If they violate it, the employee does have a right of action against the employer. Courts can void the non-compete and they can award damages, including lost compensation, liquidated damages, expert witness fees, and reasonable attorney's fees and costs. Again, the commissioner of the Department of Labor and Industry may also fine the employer $10,000 per violation. So this is something to really keep in mind. And I have employers that generally, I have not a client, but I know of someone generally that makes everyone sign a non-compete, no matter their job. That is a major no-no. Is Mark telling me to shut up? So keep that in mind. Now, finally, how much time do we have? I'm keeping you much longer than I thought, and I apologize. But finally, we have the Virginia Workers' Compensation Act. That applies to employers who have more than two employees or two or more employees. Keep in mind, just because someone gets hurt at work, well, let me back up a little bit. The Virginia Workers' Compensation Act is designed to compensate employees who have sustained work-related injuries or diseases. I told you what the threshold is for employers, and if you meet that threshold, you need to have workers' compensation insurance. The commission is certainly coming down hard on employers that don't have insurance, that should have insurance, and you are going to get fined, more likely than not $5,000 or more, for the act of not having insurance. And then ultimately, if the claim is awarded, you're going to have some responsibility to pay that claim, even if it means being the subject of litigation filed by the Office of Attorney General. So get workers' comp insurance. But I've handled 10,000 workers' compensation cases, but just because someone gets hurt at work doesn't mean that it's a compensable claim. They can certainly file a claim, but it doesn't mean it's going to be awarded. There are specific criteria in Virginia for what is compensable under the Virginia Workers' Compensation Act. An employee has to have injury by accident arising out of and in the course of their employment. An injury by accident means you have to have an accident or a specific event resulting in structural or mechanical change to your body that arises out of your employment, meaning it resulted from a risk peculiar to your employment at a time when you were doing some part of your job that you were expected to do. So, for example, I'm lifting boxes all day long, for an 8-hour shift. And at the end of the day, my back is killing me. I go to the doctor. The doctor says I have a herniated disc. That is not compensable in Virginia. I'm lifting boxes all day long, and at 3 o'clock, there's one box in particular that I lift, and I hear my back pop. That is compensable in Virginia because there was a specific event. In the first example, there was not a specific event, so it's a gradual type of process. I will tell you, I've been heavily involved in this year and the last several years. Virginia is an outlier in not recognizing these types of repetitive motion or gradual onset injury types of claims. So the General Assembly is hot and heavy on amending the Virginia Workers' Compensation Act to make compensable these types of gradual onset claims. This did not happen this year, honestly, because it also affects state employees, and the state doesn't have it in their budget to pay those claims. But I do anticipate it coming back next year. It was here last year. It got killed again this year. Then there's budgetary reasons. It's going to come back next year once the budget can be fixed. So injury by accident claims are covered. The other types of claims that are covered are occupational disease claims. Around here, we think of like coworkers pneumoconiosis, but also asbestosis, bisonosis, things of that nature. Those are more complex cases. Right now, carpal tunnel syndrome and hearing loss are covered as compensable if certain criteria are met, as occupational diseases, technically ordinary diseases of life, but they're under the occupational disease statute. You are not required, if someone gets injured on the job, to provide them with light duty, but it is smart for you to do so because it cuts down on the workers' comp exposure. Because if they're making wages, they're not entitled to wage loss benefits. I will tell you, a big component of workers' compensation cases nowadays are the medical expenses. I have seen back surgeries out of Richmond or Northern Virginia that are $800,000 each surgery. These are not complex back surgeries. The pricing is very high. Virginia does have a medical fee schedule that tries to limit some of that. It's not tied to Medicare, but it is a fee schedule. And so employers are required to reprice the bills, not employers, but the workers' comp carriers, reprice the bills on the medical fee schedule and then pay those bills. So I've covered a lot of territory. I've talked very fast, and I apologize for that. I appreciate everyone's time and attention, and there's some chats in there. Is Mark telling me to shut up?
No, sir. I just posted your contact information in the chat.
So hopefully I haven't bored people to death, but there's a lot of information. Human resources is very complicated and broad. So I'm happy to talk to anyone about anything, honestly. So that's all I have.
Any questions for Mr. Murphy? All right, well, great job. Thank you, Ramesh. We also want to thank our partners at the Washington County Chamber of Commerce. I see Nita Farmer is with us and Isaiah Thomas from the town of Abingdon. Join us on March 19th for our new knowledge when we will hear about cybersecurity and merchant services from our friends at First Bank and Trust Company. And as always, you can check back. And if you have questions, you can see this video as well as others on our YouTube channel for new knowledge. So thank you, Ramesh Murthy, and thanks everyone for joining us today.
Thank you.